Good morning. Welcome back. I am your host every Saturday morning right here on Court Radio, located forever on 100.3 WRNB.
And Classics 107.9.
Yeah, we shortened the intro a little bit, didn't we?
A little
Tactics?
bit, a little bit.
Yeah.
You request?
And it happened.
Yep.
It's nice. Okay, folks, we've got our live audience on YouTube. Welcome, folks. Thank you for joining us. And make sure you subscribe and like. For our terrestrial radio listeners, welcome back. And we always appreciate your questions. If you've got questions, legal conundrums that you need solutions to, now is the time to give us a call at 215-227-2727. Your question will get answered today. Promise. Cross my heart and
hope to die.
There you go. You remember when we used to say that, Manny?
No. Yeah, we were little kids.
No.
It's a long time ago.
Yeah. Very, very long time ago.
We have a special guest in the studio today. I'm just going to get right to it. Ian Norris. You know, he's an attorney who represents victims of nursing home abuse, medical malpractice, and funeral home neglect. We're taking your calls, 215-227-2727. I had a case like this a while ago. Some funeral home was stacking bodies for a long time in, like, unsanitary conditions. And
it's come up again fairly recently, yeah.
Yeah, and the families were devastated by the condition of their loved ones. They were mixing bodies up, and it never really. I mean, we resolved the claims, but I wouldn't say that they were significant settlements. But Ian here in the pre-show lead-up has indicated to me some, I would say, some very impressive results he's gotten. By the way, do you know that my middle name is Ian?
I did not know.
Yeah. That's a little.
How long have we known this guy?
Guys,
none of us even knew that.
Little trivia question.
Ian.
Yeah, we'll bring that back in about 10 years.
I-A-N?
I-A-N.
And that's the way you spell it. Ian's giving off MMA vibes, isn't he?
Yeah.
Mixed martial arts?
Yeah.
Jiu-jitsu?
Yeah, he's a McGregor look-alike.
Sure, yeah.
I get that a lot. No, that was one of my big passions for a long time.
He's all tatted up.
Yeah.
Yeah.
He does not look like your normal attorney.
Not at all. He'll fight for you for real.
I try to keep the suit on to make sure that, I hide the true nature of who I am.
He's a beast.
Where did you go to school, Ian?
So I went to Dickinson College for undergrad,
Oh,
and then
familiar.
Duquesne University for law school. Graduated from
You a
there.
Pennsylvania boy?
I am. Warren County, Pennsylvania.
Warren County. Do you need a passport to get there?
You do. It's a 6-hour drive within the state. It's a passport, and then it's a check when you come back into Philly.
Wow. Ooh.
Oh.
Oh my goodness, that never happened.
I've heard that theme before. I can't remember where I've heard it though.
Yeah, it's an iPhone theme.
Mm.
Okay, let's get back on topic here. Give us just like a synopsis of. We'll start with nursing home neglect. What would you deem to be a valid nursing home neglect type case?
Absolutely. So nursing home neglect, it takes a number of forms. Probably the most common that you see in what most residents and their family members see is based in a short staffing kind of scenario. For the most part, It's bed sores, usually in bony areas like your sacrum, hips, heels, and then fall fractures, broken hips, shoulders, basically anything where a resident is relying on staff to come and provide what are called activities of daily living. So just getting you up to go to the bathroom, getting you ready for therapy. Staffing impacts that stuff immediately. As anybody that's been in a hospital knows, you ring a call bell, even in an acute care setting, you're waiting a long time for someone to show up. In the nursing homes, especially in the for-profit business model, staffing is the most expensive aspect of it. As soon as they start cutting that, that's when you start seeing an increase in these call bell response times, which leads to elderly individuals or anybody. I'm not going to sit and wait. I want to go to the restroom. I'm not going to try to soil myself. But for the most part, they can't get up and walk on their own. They can't do a lot on their own, and then they end up trying to do that. And that's where you get the fall fractures. With bed sores, it's a turning and repositioning issue. Anybody knows when you're sitting for just a little bit too long, your butt starts to get a little bit sore. That's because the blood is not getting down to the area where that bony prominence is. And the longer you sit on that, you start to get skin breakdown. You tie that in with not being changed when you need to, and you're soiling yourself. And it just turns into what the storybook definition of neglect is, which is the failure to provide goods and services that you need to prevent these injuries. And those are primarily what we see. And then there's a dehydration aspect. It's a little bit more complex, but it's the same thing. You're not getting water provided to you. You get dehydrated, and you start to get urinary tract infections. And it cascades.
Let me throw a little curveball at you. So often today, families will find themselves in a nursing home. They come in, they ask the questions, the right questions. They get what they think are the right answers. And then the nursing home slides across a sheath of papers for them to sign. And contained within that sheath of papers is some clauses that may impact your ability to prosecute a claim against the nursing home to the full extent of the law, because it might divert your claim into some alternative litigation venue. What is it, and how serious is that to prevent you from getting full justice?
Quite honestly, it is the number one way in which nursing homes are able to limit their liability. They like to call them alternative dispute resolution, arbitration. They'll use any type of label that they can on it to not name it what it is, which is to limit their liability for the negligence they're causing. Why this is very important is it's a Seventh Amendment right to a jury trial. You have a right to have your peers make that decision for you. But by them putting it into a sheath, and you're right, Dean, I mean, it sometimes can be a 60, 70-page admission agreement, which you have to sign the admission agreement to get in, but the arbitration agreement, you don't have to. But it's presented in such a way within the documents that for a family member, especially, you're trying to just get somebody in to get taken care of. You're in a very tough situation emotionally, financially at some points, and you're just trying to get them in, and you're like, what do I have to sign so that my loved one can be taken care of? And then what ends up happening is this arbitration agreement is slide in front of you. You have 30 days to get rid of it, but they don't really tell you that. They do, but they will gloss over it quickly, give you the big sheath, if they do give you a copy, for you to take home. And then what happens is it severely limits your ability to get any sort of recovery for what happens. I mean, they even cover instances of rape in these homes. They will be enforced not just for a slip and fall, not just for a bed sore. You could have someone that actively assaults you sexually, and that is covered under this agreement. The public will never know about it. The arbitration award is going to be confidential. You're never going to be allowed to talk about it. And ultimately, that in no way then provides any sort of prohibition on that future conduct continuing to occur by the nursing home. So you do everything right, but if you happen to have a power of attorney for your mother, or they may have your mother sign it after you've left the building, if you didn't choose to sign it, if they're cognitively able to do so, it's to the point now where I've been fighting that my whole career. That's always been one of the big arguments. In Pennsylvania, it's really boiled down to primarily, did you have authority to sign it or not? Meaning, did you have the power of attorney or did you do it? And really, I recommend to everybody, and we do it in powers of attorney that we create for our clients, a specific line that says, this does not authorize my agent to sign away my Seventh Amendment right to a jury trial.
Wow, cool.
And that's really the best way that you can protect yourself, because otherwise it's almost impossible for us to beat.
I hope you don't mind. I'm going to steal that line.
Yeah.
I'm adding that to all of our powers of attorney effective Monday. I guess the question is, I mean, we want to give somebody a tidbit today. If they take away one piece of advice with regard to that clause, what is it?
Don't sign it. That is the number one piece of advice. It in no way assists a victim of negligence. It assists you in a collection action. Do you necessarily want to be in court if you're trying to get them to pay you back for maybe something that you left in your client trust fund? But in reality, it's just there for them to use as a cudgel against you and protect themselves from, I mean, you know as well as I do, when you're looking at a case, excuse me, and you get an arbitration agreement, your evaluation of that case drops precipitously because a jury of your peers really makes a determination as to what the value of your injuries are. When you have a lawyer or a retired judge sitting across on the other side, we have been trained our whole lives to not have emotion in what we're doing. And when we analyze and assess a value on a case, we're not looking and going, oh my God, how did this happen? This is horrible. This shouldn't happen again. We are being empowered as an arbitrator to go, what is the fair value of this? And we have 30 days to think about it. A jury of your peers hears all of that evidence and is making that decision with the impact of that evidence as it occurs. Arbitrators step away from it, do every other aspect of their life and their job, and then come back, and ultimately you lose out, and more importantly, there is no deference or change in the behavior of the nursing home because the whole reason they put it in there has been effective, which is you didn't get your day in court. So do not sign them.
Okay, so there it is, folks. If you find yourself in the office of a nursing home prepared to sign papers, bear in mind that one of those papers is going to be to give up your right to a jury trial. Identify that paper. Tell the administrators, this one paper I'm not signing. Put an X through it and move on. And then you maintain and retain the right to bring a jury trial if there should be any negligence. All right, we'll repeat that again, I'm sure, more throughout the show. But that's the one piece of information. If you take nothing else away from this show, do not sign an arbitration agreement. And it doesn't even apply simply to nursing home type claims.
Good point.
They're sticking these arbitration clauses in everything. Don't sign them. And if it's is it a requirement? Will they turn you down as a patient if you say, I'm sorry, I can't sign this?
That's a very key question. They are not allowed legally to make the signing of an arbitration agreement a condition of admission. So any implication they give to you when they're providing it to you, hey, you have to sign this to get in there, they're not 100% wrong because you do have to sign a lot of documents to obtain admission to a facility, but not the arbitration agreement. A kind of corollary to what we're talking about of your advice is if you have put a loved one in a nursing home or you have been in the last 30 days, typically there's a 30-day period in which you can rescind that agreement. I would recommend you look at your admission papers or request a copy, look and see if you signed that, and specifically write a letter, keep a copy of that letter and an email because you're going to have evidence of it, or otherwise, lo and behold, it'll get lost when we're doing discovery to determine whether or not that arbitration agreement is enforceable.
All right, there you go. So if you've done this in the last 30 days, it's not too late. Rush off, send an email, tell them that you're rescinding that portion of the agreement for the arbitration clause.
So to be clear, the statute is 30 days?
For that.
For that.
Yeah.
Now, this is normally not the client confronted with these papers. This is a family member of some sort. Most of the time, 90% of the time.
The sad part of my job is that usually my clients, the victims, have passed by the time I get the case. Usually it's a child, it's a sibling, or a husband or a wife that usually don't even have an estate opened up, because a lot of the times it's people that are on Medicaid, people that would not think to get an estate opened up. They come to us for the first time and they realize, oh, I have to open up an estate. My mom was in this facility for this long. She was there for a year and a half. She got signed in. You'll get the case. Did you sign an arbitration agreement? I signed a lot of papers. I don't know what I signed. And then we do make our initial request for the records. And as you know, Dean, what's the first thing the defense attorney sends to you? Oh, here's the records, but I want to point you to page 15 of the admission agreement. Here's the arbitration agreement. So do you really want this case? That's what they're saying. It's even if the facts are just on the edge, do you want the case if you know you're going to have to arbitrate this as opposed to taking it to court?
Gathering records can become a challenge. We're dealing oftentimes not with some mom and pop nursing home. We're dealing with corporations who have extensive experience in moving the ball in these claims and delaying the issuance of records. Yes?
Absolutely. And cost prohibitive as well. When you see the hospital defendants, anybody that uses the EPIC system, the electronic medical record system, it's a drop-down menu system. So a 5-day stay can turn into a 4,000-page record. And these hospitals are hiring companies that when you go to request them, you're looking at bills of $8,000, $9,000, $10,000 for records. You as the individual that were in the hospital or the next of kin or family member have a right to request those at a statutorily set level. But if you get a lawyer like us to do it, we're going in and trying to get records. It's a lot of money that comes out of our pocket, and they can drag it out for 60 days, 90 days. They don't pay attention to the requirements that the regulations have, that they have to provide it promptly and very quickly after you request them.
And it's not unusual, this is not like in the movies. It's not unusual when you have 4,000 pages of records for them to send you 3,800, but there's 200 missing records, which are the key records. And then you've got to review these 3,800 records, realize, because you have enough experience, that there are nursing notes or some important documents that are missing. And you've got to ask for them again, and then it's another 60 or 90 days. This process takes time.
Cumbersome.
Which brings me to the point that you should not waste time. If you believe that negligence may play a part in the death of your loved one, then you need to get with an attorney promptly, because we have a 2-year statute of limitations. 2 years. Now, it could be 4 if you have a contract claim, but that doesn't really provide you with the damages that we're looking for. You don't want the return of the money from your loved one's stay. You want to get the pain and suffering and perhaps punitive damages for the behaviors that were conducted. Those damages, the big dollar damages, they disappear 2 years from the date of the negligence. And if you waited 18 months to get yourself to an attorney's office, you've made it almost impossible for the attorney to gather the records and make an intelligent decision regarding the viability of your claim.
Correct. And I mean, there's a lot of standard operating procedures in law firms where you get a case with only 30, 45 days left on the statute. It doesn't matter how good the case is. You run the risk of malpractice because you may not be able to get all the information you need, and so you just have to turn something down. And with electronic medical records, it used to be when I started doing this, there was a lot of handwritten records. Very hard to tell when people were doing CYA documentation or adding things to the chart after the incident occurred. If you're going in and asking for these records or getting a lawyer involved immediately, now when they sign into those electronic charts, there's the date it was signed in, who did it, and what they changed. And as part of our discovery process, we always get those audit trails, and that's kind of become the new hidden thing that you look for, because all of a sudden a request for records comes in, but then we see there's changes to the physician order, changes to the nurse's notes that occurred in 2024 when the case was from 2023. Wow. And it's and another thing is you don't get incident and accident reports as part of your initial record request, and they'll never give it to a client. And those are where you're actually seeing what occurred, especially with a fall fracture. Who was on duty? What time did it occur? Were there staffing issues? That's not going to be in a nurse progress note. That's not going to be in a physician note, because they say chart by exception. The exception is they don't want to get caught.
215-227-2727. That's the number for all things legal in Philly. We're talking to Ian Norris. Ian works. Where do you work, Ian?
I work at McKeldrew Patel here in Philadelphia.
And what is McKeldrew Patel? Do they focus their practice on an area?
We have a number of focuses. Our primary focuses are catastrophic injury, medical malpractice, FELA work on behalf of unions with SEPTA and Amtrak. We do a lot of products liability. My division is the nursing home, neglect and abuse, and funeral home division. And we also have a very vibrant civil rights division.
Nice.
Yeah. All right. So let's get a caller on. We got a caller. And folks, if you got a call, 215-227-2727. We'll get you on the air. Campbell on line 4, Tactics. How are you, Campbell?
Morning.
Good morning to everybody.
Thanks for joining the show this morning, Campbell. What's your question?
Okay, I listened to you a week ago talking about malpractice. What do you do if you want or need to report a doctor to the medical board?
Okay, I'm going to get there. But I would say, remember, I don't want to beat a dead horse, but contact an attorney first, because sometimes the attorney will take care of that for you, but will also gather the records that you may need to demonstrate to the medical board the problems with that doctor. But having said that, what do you say, Ian?
I mean, I kind of go the same route, honestly, and not to me, it's not beating a dead horse, but I understand that's what a lot of lay people would think. It is best in a situation where you're going to be dealing with other professionals, especially where you're going to be critiquing how they conducted themselves and how they performed their jobs. Lawyers provide you with an easy access to a bench of other physicians or healthcare professionals that they utilize as experts in these cases, and it's a very easy way for you to give them your fact pattern specifically of what occurred and have them run it by people that already practice in that field and can let you know the pathway in the specific areas in which you want to complain about for your specific issue. I find it to be very effective, and most attorneys will do a free consultation, especially contingency fee attorneys in the personal injury realm. And so by taking that opportunity to go to speak to somebody that does this on a day-to-day basis, I think it assists you in getting your question directed to the appropriate party.
It's a lot of reading and devil in the details work with this.
Well, yeah, the records kind of tell the tale. How do you feel about cases where the records don't support your claim, but the testimony of the family and potentially the victim do?
That is a very difficult balancing act to walk because families perceive information through a different lens when you're going through these situations. They're obviously very emotional. There's a lot of cares and concerns that are going on that your version of events is definitely true to you. It definitely is. But our experts do require that the records to some extent support what they're looking at, because they're required to file what are called certificates of merit. And we are not allowed to just come in and go, hey, my client said this is what happened, so this is what I think happened. This doctor needs to be sued. The problem is, which is a good thing in Pennsylvania, to sort out lawsuits that don't really have any basis in fact, is to have an expert that can come in and say, yes, there's a deviation from standard of care. However, there's certain types of injuries, there's certain types of cases where the family's observations, especially if you take it back to nursing home cases, turning and repositioning your family member, they'll put in their chart, they'll check off the box every 2 hours. We did it, we did it, we did it. But in reality, you have a mom or a son or a daughter who sat there for 8 hours and saw someone come in one time. That is information that's important. But it's a tough part of our job. You have to do a credibility analysis of your client when you're doing that as well. So you can't divorce both. And unfortunately, there's cases I want to move on just based on what my client says. but I don't have a gerontologist that will sign off on a certificate of merit because they say, listen, I can't even infer there was any change to these records. I have to take it at face value. So it's a tough call in medical malpractice and nursing home type cases.
I second Ian's position. When we have claims that are not supported by the records, and then the client will say, well, they doctored the record, and that's why it's not supported by the record, but you should take my word for it. Those are tough cases because, again, there is metadata that is contained within the records. Metadata is when the information was inputted, who inputted it, whether it was changed somewhere down the line. And that's not something that the doctors or nurses can mess with. And so when the metadata is not supporting your claim, the records don't support your claim, rarely, if ever, will an attorney go forward, an inexperienced attorney, one you don't want to have standing next to you at the time of trial, may do that. But anybody who is worth their salt and knows how this process works and has been burned by it once or twice, they quickly learn that the records must speak for themselves. And if it's not in the records, for all intents and purposes, it didn't happen.
Unfortunately, and that works for us as well. In the nursing home realm, not documented, not done. It's a nursing maxim that most nurses are taught, and they try to hide behind I used the term before, charting by exception, but in reality, there's certain things they have to document every day. And one of those are turning and repositioning, whether or not there are complaints, whether there are changes in condition. And if it's not documented, it's not done. And so if they're saying to you, I provided wound care to your mom every single day. We went in, we changed the bandage, we made sure to change the solution, we made sure to clean it. It has to say that in the chart. If there are blanks in that chart that they're on certain shift, it's not in there, no one's remembering as a care provider what they did a year ago on an individual. And so they have to agree, we didn't do it there if we didn't document it. So to get back to the record discussion and argument, we can infer our job from absences in the record. So it may not be in the record, but that might support the type of claim we have, which is you're checking on someone every 2 hours so they don't have a fall. Then they don't check every 2 hours. It's not documented, but a fall occurred. You can infer that that's what happened.
So in God we trust, everyone else bring data.
Yes.
Folks, we're up against the break. Can you believe we're at the half-hour mark?
Yeah.
215-227-2727. If you've got legal questions, join in the conversation while we're on break, and we'll address your question when we get back.
You guys see this conversation about Dean and his kids?
Yeah.
What was that?
You've arrived. Mia's going to put Dean in a nursing home. Oh, no, she's not. Jackson and Sophia will take care of her.
I don't think they'll let me through the door anywhere. I'm going to have to go under assumed name before I go in.
And feel free to bring this closer.
I'm going to bring you down here a little bit.
All right.
Yeah, you got to deep throat the mic.
Got it. Yeah, I got it.
Since you're speaking, speak right into that as you speak.
I got it.
Somebody in the chat asked if you had any local recommendations, if you could answer that.
Oh, nursing homes?
Yeah.
I don't do that as a matter of course, just because it gets to a point where I have an answer for it though. So in the sense of what I say is I don't recommend or not recommend a place, but CMS has a very robust website that you can call Nursing Home Compare, where you can actually see what their staffing numbers are, what their health conditions are, how they rate against other facilities, and it's literally a 5-star system. So you can look at that, and then the state of Pennsylvania also has a website through the Department of Health where you can look at Department of Health surveys that show where they're not adhering to the regulations.
Okay.
So that's I stay away from recommending because then you can get in
Yeah.
trouble because then someone's like, you told me this was good. You go
Right,
in.
that's bad.
But the Medicare and Medicaid give us a good way to track that.
Okay. Thank you.
And every state's different. My practice in Arizona and New Mexico, they do not have their state health departments are not as in depth as ours are. So you just don't have the same amount of visits, the same amount of identification of deficiencies. PA is a great place actually to be in a nursing home if you're going to have to be in, and there's pretty bad ones here. But when you go to Colorado and Arizona and New Mexico, it's terrifying.
Oh, really?
It's terrifying, especially Colorado because they cap non-economics at $300K. So if you're old, you're not getting anything.
Yes, baby. Good morning and welcome back. I am Dean Weitzman, your host every Saturday morning right here on 100.3 WRNB.
And Classics 107.9.
We bring you Court Radio, the place you can get your legal answers issued to you quickly. And today we're focusing our show on nursing home neglect and funeral home neglect, which threw me for a curveball because I didn't think that was a thing. I mean, I knew it happened occasionally, but I didn't know anybody would build a practice around it. How many, funeral home cases in comparison to nursing home cases do you get?
Well, and let me respond to the first thing. I did not think I'd be building a practice on it either.
Okay.
It came to me through a referral source that was also a nursing home referral source, but they kind of dovetail off each other. From a numbers perspective, nursing home cases a lot higher than the funeral home cases. It doesn't happen as much as you would expect it to happen, but it happens consistently enough that you can build a decent practice on it. I would say probably 25% of what I do is the funeral home practice. Nursing home practice, we have to turn cases down. There's so many cases coming in, and we've seen that more since post-COVID. Staffing really took a hit during COVID, but the nursing homes didn't keep making money. And so when they realized they could keep making money at those staffing levels, you didn't really see them jump back, even though people were looking for jobs. You also see in the nursing home realm, the staffing ratio. Pennsylvania used to require only 2.7 hours of direct care a day. That has since increased to over 3. That makes it difficult on the nursing homes that are looking for a bottom line where they're trying to make profit, and which that's what the majority of them are in the business to do. But staffing is over 50% of the budget. And so those cases are a lot more common, and we see them coming in more often. However, the funeral home cases I get coming in they're egregious on their face. They're things you would never expect. A lot of the cases I see more often than not are wrongful cremations, where it's an individual never authorized a cremation to happen. Their loved one gets sent in on a Friday. They go to meet somebody on Monday, and they're like, "Oh, I'm sorry. We went to reconcile the bodies in the cooler today, and your dad's not there because we cremated him on Friday."
Ouch.
How about like plot disputes?
Plot disputes happen a lot, but not so much in that, hey, I bought this and someone else bought it. What you see is there's the body that was buried there originally when the plot was bought, and a loved one's been going to pray or say, talk to on a day-to-day basis. They find out that's not their loved one. It got moved to another grave. We have a current case that's in investigation and intake right now. I can't say the defendant yet, but it's well known in the area, and it was a mausoleum where the mother and daughter got plots. They wanted to be by each other. She kept going there assuming she was talking to her mom, and in reality, they had sold the plot to somebody else and moved the body to somewhere else.
I hope the new body spoke English. I mean, it would be a real problem. I mean, if they didn't even understand what was going on.
Yeah, I'm with you. I'm with you. Yeah.
But
I want to say that early in my career, I was kind of a trendsetter. I had a case against an at-home health agency. This is a whole different kind of, it's similar, but it's a different area of the law. And they were doing a really poor job of investigating and vetting employees who they were sending into homes. In homes, the people are even more vulnerable. In a nursing home, there's other people around. There's nurses
Maybe
and
cameras.
doctors and. But in a home, it's your private little castle. Nobody's there to protect you.
Yeah.
This fellow was a drug addict. He was a crackhead. He came in to rob them when they thought he was coming in to fill out paperwork. The long story short is he killed the wife of his charge, and we brought a claim. I'm talking 20 years ago.
Home health aid.
Home health aid. We brought a claim against the Home Health Aid Agency for negligent hiring. And that case settled for 7 figures. But are you seeing that?
We are, and we have a number of those in our inventory right now, but across the board, those are starting to rise because a lot more people are taking the option of having an in-home health aid, and these companies also, they sell themselves by saying your family member can do this, your family member can come in, but in reality, most people don't have family members that can work in that type of position, and so you do have strangers coming into your house, and a lot of them are good people. A lot of them, it's very tough work because these people do have dementia at times, but they aren't in a position where their family wants to place them in a memory care unit into a nursing home. However, they're extremely vulnerable to financial abuse and neglect. You have these people coming in, and lo and behold, I had a case where she was literally got his checks signed over to her. It was hundreds of thousands of dollars that are being signed over to her.
That sounds about par for the course.
Right.
Yeah.
And then you also have ones where people get into altercations. They don't like the aid that's there, but they're frail. They're elderly. I've had cases where they've been thrown down the stairs, broken shoulders. And it's these cases are increasing in frequency for, I say good, bad reason why I say that is you have better outcomes when you're at home. That's without a doubt. You go into a nursing home, your life expectancy drops considerably. And especially when your rehab gets done. That's the big thing about nursing homes that people don't realize. When you get that tour that you're talking about, Dean, where we're looking at the admission agreement, they're taking you to the best part of the nursing home because the hospitals are referring their patients to your nursing home. So you want them to see the best part. And more importantly, Medicare is paying for that first 100 days, and Medicare is the highest payer that you have. So they want to get those hospitals keep sending people there. When that Medicare runs out after 90 to 100 days, you go to the long-term care side. That's Medicaid. It's completely different. The lighting's worse. It's your staff.
Solitary. It's the
It's
whole.
the whole. Yeah.
And it's not far from that.
Let me tell you something. If you walk into a nursing home and you smell urine or feces,
exactly,
spin around and get out.
Yeah, because that's the best part they're showing you. Because that's the best.
And if you smell it, then it's a problem.
You're in real problem.
Yeah. Yeah, and folks, they're going to ask you to sign that same arbitration clause if you're doing the treatment at home. Remember, we started this show, and I promised you we'd repeat it. If you've been given an arbitration clause, when you get your sheath of papers, tell them, could you please identify the arbitration clause? Because I was listening to Dean on Court Radio, and I need you to show me the arbitration clause. Then put a big X across it and move on. That's if there's one thing you're taking away from this show today, that's it. Because if you sign that arbitration clause and God forbid something happens, your case will be looked at askance by any attorney who knows what they're doing. The value of your case will drop precipitously. 215-227-2727. Let's talk to Carla on line 2. Welcome to Court Radio, Carla.
Morning.
Morning, Carla.
Good morning, guys. How are you?
I am great.
Very
and
well, good.
My guests look like they're doing well as in addition to me. What's your question?
My question is not in reference to nursing home. It's in reference to my daughter. She's 26 years old right now. She was born blind. At the age of 12, she developed cataracts. Over that year, they calcified. Now, we knew if we removed them, she wouldn't have sight, but at least she wouldn't have the white dots in her eyes. We had them removed. next day, she started having pressure. So she had to go back in for a second surgery. During the second surgery, the first physician called in a specialist to help him. So now she's 26 now, and she's still having problems with her eyes. I was not told that they removed her lens during the cataract surgery. From what I know of cataract surgery, you don't remove the lens. So she's seeing a specialist now for something else. And the specialist let her know, well, she doesn't have a lens. And I'm like, what? She doesn't have lenses? She just had cataract surgery. There's no reason for them to remove her lens. So now I'm going back to the first doctor, trying to get all her medical records, and we're having problems with them giving us her medical records. So I'm at a loss now. I don't know what to do, if I should pursue it, if I can pursue it.
No.
But
no. The quick answer is no. If your daughter had this surgery at 13, there's something called the discovery rule. And so for a minor, the claim would be told until she turned 21, and then they would tack on 2 years from that time. Well, actually, let me strike that. 18. 18, she's legally entitled to bring a claim on her behalf. Then they tack on 2 years for a 2-year statute of limitations, which would bring her to 20. If she's 26 now, her statute of limitations has expired. Yours has long expired. And, when the discovery rule is it's not clear cut. It's a funky rule. If, for instance, they left a scalpel in your belly or a sponge in your belly during surgery, and there was no symptoms, and that's the key, no symptoms, for 20 years. And on the 20th year, you start to get some agita, and then all of a sudden you get some infection. The doctor investigates, does an ultrasound, and goes, lo and behold, you've got a sponge in there. Did you have surgery? Oh, yeah, 20 years ago. Then you could still bring a claim 20 years after the incident because you had no reason to know that there was negligence committed 20 years earlier. And so they told that statute. But as you describe your daughter's matter, you knew back in 13 that there was a problem. The cataract.
I didn't know they were removing her lens,
she had to have a subsequent procedure, which caused, I assume, blindness. There was indications early on that there was a problem, and so that statute did not toll. It clicked along for you, and 2 years later it was gone. And for her, it clicked along until she was 18, and on her 20th birthday, it disappeared. So from all intents and purposes, I do not see a valid claim here that you could make on her behalf.
Okay.
I am sorry, Carla.
Thank you for the clarity. No reason to be sorry. I mean,
I like to give good news to people. She's
getting along well. It's just that she keeps having this reoccurring issue with her eye, and I was just wondering, was that brought on by the surgery? And for the fact that they removed her lens. No one told me they had to remove her lens to perform a cataract surgery.
I'm not gonna give you 100%. You don't have a case. I'm not. Because you throw little facts in there which make me go, like you didn't know a lens was removed, and maybe that played a critical part. Let me say this. Gathering the medical records is critical to the potential proper analysis.
But she's having problems getting the records.
They won't give us the records for whatever reason. We've been trying this entire year.
Yeah, well,
so
13 years later, they may not have the records. Not sure, but practices are bought and sold, and they have a legal obligation to hold them for a certain period of time. I'm not sure 13 years would work. It may be 10 years that they have to hold them for, or 7, or what have you. So there may not be records to review at this point. It's been so long. Again, if you want not a thumbnail explanation on a radio show, but you want a deep dive analysis, you should contact an attorney who may, I'm not saying, again, there's a lot going against you here, and attorneys, like anything else, are a business, and they weigh and measure the risks involved and the potential recovery and decide whether they want to even get involved. But if you want to call my office on Monday and ask for Jay Berger, Jay has a dare I use an old term, Rolodex of attorneys that we feel that are exceptional in their area of practice. So if it's not an area that we want to focus on, we have others like Ian Norris. Yes. That we say, hey, Ian's spent his practice focusing on this. He'll be a better fit for that, and we will refer the matter to Ian. And so we may have somebody to refer you to. Call on Monday, speak to Jay, and let's see what we can find out. But I don't give you a lot of hope for the way you've described this, but I can't tell you with 100% certainty there's no claim. Okay?
Okay, can you just give me those two names one more time?
Jay Berger. 215-227-2727. The same number you call for all your legal issues.
Gotcha. Thank you, guys.
Be well, Carla. Thanks for calling Court Radio. 215-227-2727. Put it in your cell phone. It's the only number you need. And then we will get, either we will take care of it or we will get somebody who is fine to help you with it. Unfortunately, I'm getting the break signal from my key tickler, and that would be tactics.
Thank you.
Yeah. And we're going to take a quick 2-minute break. We're coming back with Ian Norris. We're talking about nursing home neglect. I got some callers on the line. Stick around, and we'll see you back here in 2 minutes.
I'm just enjoying reading these comments.
We'll hit some of those on live. Folks, we'll hit your comments on live when we go off the air, so stick around. And remember, subscribe and like. I should sit up a little higher, my Brenton says.
Oh,
yeah, baby.
I think he has a person that's criticizing on the camera.
No, this is just me.
Oh, okay.
I majored in this, remember? It's all coming back.
Oh.
Radio, television, and film, Temple University, class of 83.
Oh, okay.
Now look at Dean now. I love Temple University.
Like everybody yesterday was like, Temple.
That's right.
Temple.
I could have gone anywhere I liked. I chose Temple.
I went to school.
I ain't going to bullshit. I couldn't go anywhere. I even had to beg Temple to let me in.
Please. I've got no place else to go.
It's like Carlisle was nice for 18 or 22 years.
Oh,
If I would have been that age in Pittsburgh, it might have been a problem.
It was fun though.
Yeah, it was great for law school. I didn't know it was a Catholic school going. I went sight unseen and showed up, and there was a huge crucifix. I was like, well, I guess I should. Yeah, because I didn't get into Temple, so I was like, oh, I guess I'm going to go to Duquesne. And no one told me. I was like, oh, that's probably not the. Should have looked into that. But
What were you? That you were just not practicing any religion?
I was an atheist. Yeah, my major was history. I was like philosophy. I was like this whole, and I was like, I wanted to either go. I couldn't go to Dickinson Law because my girlfriend was still there and all my friends were, and I'm like, if I do that, I won't graduate.
You won't graduate.
Right.
Not gonna happen. I'm like, I want to go to Temple because I wanted to do the trial ad, and then I think I just didn't do my application right because I never even heard back. Duquesne offered me some money, and I'm like, oh, I'll go sequester myself out in Western PA. I should be fine. Barely made it out. It's like, law school was miserable.
Actually, for me, it was the only academic exercise that actually I excelled at.
Yeah.
I barely got out of high school. I barely got out of college. But law school, I
just
shined like a
clicked in.
motherfucker.
I love it. See,
Did I say motherfucker?
You did.
Yeah.
You did.
All right, we're back. I'm Dean Weitzman, your host on Court Radio. Was there a little delay terrestrially?
No, I didn't pull anything up. So,
you got lucky. Yeah.
in the air ether.
People on live get to see the real Dean Weitzman.
And hear him, too.
Yeah. And so if you want to really catch the real deal, the unfiltered.
That's the word.
The unfiltered deal. You gotta watch this show
after
live.
We go off the air.
Yeah.
Ooh.
Yeah, you can get there by going to My Philly Lawyer's website, clicking on the Court Radio button, and it'll take you right to the live button, and here we are.
We should do that. Court Radio unfiltered after the show.
Ooh, I like that. Yeah.
After coffee.
Yeah.
All right, let's see. I got a question on line 3 from a regular, so I feel compelled to give her a moment. Velda on line 3.
Oh, a regular am I? Good morning, everybody.
Morning,
Listen,
Velda.
I show love to those who show love to me.
I'm sure do. I love you guys. But listen, I have a cousin who had a stroke in 2013. He's married, and the wife tells the mother and the sister she cannot help him. She can't stay. She abandons him and leaves him to the care of his mother and his sister. So for several years, they were taking care of him through this stroke. He wants to find her and get a divorce. And with my legal limited ability from you guys, I told him at least abandonment. But what other grounds can he file for a divorce?
He doesn't
Then he
need,
can find her.
baby, he doesn't need any other grounds. 2 years from separation, and it's not a legal separate. You don't have to file a document, but you make an allegation in your complaint that you have been living separate and apart for 2 years, and it really doesn't matter what the reason is. You now have a valid basis for a no-fault divorce. The key part, Velda, that you mentioned is where the hell is she? And, it becomes a little more expensive and cumbersome to get that divorce because you have to serve the individual. Now, you can serve them by posting their last known address. The sheriff goes and tacks up a complaint at the last known address. You might have to advertise in the newspaper, but you can achieve service, and once you've achieved service, he's divorced. Bear in mind, if he never does that, she can come back in on his death and take 1/3 of his estate as his the minimum spousal portion that she's entitled to in Pennsylvania, even if he has a will and even if he disinherits her. She can suck 1/3 of whatever he's worth right out. So it's critical, especially if he has assets, to sever that relationship legally by getting divorced.
That's what I told him. So, okay, you have solidified that for me. I thank you guys very much. And if I don't call again before Thanksgiving, enjoy your wonderful holidays.
Thank you, baby.
Thank you,
Take
brother.
care.
All right, take care.
Yeah.
So abandonment, huh?
Abandonment, yeah. But any separation,
Right.
2-year separation, no fault divorce in Pennsylvania, hasta la vista. It may
Baby.
be less than 2 years now. It's been a while since I practiced in this area. If you call My Philly Lawyer, we have a cadre of attorneys for various price categories. In the divorce world, it really is.
I think it is down to 1 year.
Okay.
Is it?
Yeah.
It's down to 1 year.
You may be right. In the divorce world, you really need to find the attorney for the asset value that you have. If you have gazillions of dollars, you do not want a $250 an hour attorney. It's just the way it is. And so usually I will ask somebody calling into the office for a referral for a domestic relations attorney, what is the value of the estate? How much is there to fight about, and kids and all that stuff? And then the more complicated and the more expensive it is, you're getting the higher end attorneys with more experience in those larger estates. 215-227-2727. We've been talking to Ian Norris, who I'm quite impressed by, I have to say, and I don't say that often.
Appreciate it, Dean.
He never says it, Ian.
I really don't. I'm going to make sure that Ian gets a fair, sizable portion of our referral work on this area. He's served himself well here. First of all, you genuinely seem excited about representing people in this area, and I think that's an important part of the puzzle.
Yeah, I mean, I absolutely do. I got lucky and fell into this in Duquesne as a law clerk. I got with a firm called Wilkes & McHugh.
I know that firm.
Yeah.
Did they blow up?
They did.
Okay.
Yeah, they did.
Because of
wait,
you?
wait, what do you mean?
Yeah, because of me. I left, and
Oh, so you mean they broke up?
Yeah.
Okay.
Yeah. But it was one of those things that I knew I wanted to be a trial lawyer, but I didn't know what type of trial lawyer. And then when I started doing this type of work, the passion almost comes of its own, because they are literally the most helpless individuals that you can represent, yet they've already lived a life and contributed to society. But the way the law works, which is the saddest part, is the real money is only ever in what did you lose in earnings? What is your future earning capacity, not what you've already given to society and to the population. And
that's unfortunate.
Yeah.
Because these folks most of them are well beyond their earning years.
So far beyond. And they've done everything to raise children, contribute to society, and somehow their life is only worth their pain and suffering. And that's a difficult thing to tell to people, but it rings true with juries when they realize this is what could happen to my family member. This is what could happen to me. And how are we treating the most vulnerable who've already contributed to our society like this?
And now Ian and I haven't had any pre-show get together. So I throw questions at Ian and he has no clue what's coming.
True.
It's a little scary for him, but have you tried a case?
I've tried a lot of cases. Yeah.
Okay.
And I've done.
In what venue? Have you tried a Philly case?
I have tried a Philly case. I've tried multiple Philly cases. I've tried cases in New Jersey. I've tried cases in Colorado.
And let me say this, folks.
And I'm licensed in 7 states. I'm all over.
7 states.
7
My
states.
God.
Hey.
He was this boy was a slow starter, but he's really taken off.
Right.
Not every attorney out there has experience trying cases.
That matters?
Oh, my Lord, does that matter? Because otherwise, all the guy's doing or the girl's doing is trying to set himself up for a quick settlement.
Right.
They're scared to death to get into a courtroom and actually communicate with a jury. If your lawyer hasn't tried a case in his career, that's probably not a lawyer you want. Give me the best. You got 1 minute. Give me the best result on a trial that you had.
So I had a 0 offer on a case up in Monroe County, Stroudsburg.
Where is Monroe? Oh, Stroudsburg.
Yeah, way up northeast.
Yeah.
Fall hip fracture, no death. We went to trial. It was a 5-day trial. Great trial. $1 million, $250,000 for the pain and suffering, $750 for punitive damages. It was a phenomenal case based purely on the understaffing and the changing of records, just like we talked about. What occurred on the day of the fall. Incident report comes 3 days later, and lo and behold, the nurse aide's testimony changed. And
why do you think they made you a 0 offer in a case that seems on all fours like it was a pretty strong case?
I honestly think because it was Stroudsburg and it's a nursing home case and there was no death involved. It was a guy that fell, and quite honestly, it's because the defense attorneys and the defendants believed their own false charting that this guy had slid out of the chair on his own just out of the blue, when in reality he said, I'd been in dialysis, I was exhausted. They left him in the chair because of short staffing. He slid out, fractured his thumb.
Let me say this, folks. Monroe County is not a place you want to try a case.
No.
And to get $1 million is extraordinary.
Folks,
we're all out of time. Ian, I'm so sorry. The hour goes by quickly.
So fast. Appreciate it.
Folks, we'll be back next Sunday. Yeah, well, we're coming next Sunday no matter what.
Yeah.
So you get yourself tuned in. We'll see you then. Have a great week. Love you. Bye-bye.
And now it's
We're
time for
still on live.
Unfiltered, ladies and gentlemen.
Yeah, unfiltered on live. You heard me use the MF word. I just want to say that neither Mia nor Sophia. Now, Jackson is a whole nother story.
Come on.
But Mia and Sophia said to me they will keep my decrepit ass at home till the day I die. So
You got it in writing?
I do not have it in writing, but it is an oral contract.
With a home nurse's aide.
Those are enforceable in Pennsylvania.
Yeah. What else is going on in live, folks? You have anything else you want to add to this conversation?
There are a couple of folks that want to work for Ian.
Work for Ian.
Work
All
him.
right. Was this an
We're
interesting?
always
Let me
looking
just
for
ask my
talent.
live audience:
Always
was
looking
it
for
an
talent.
interesting show? Did you get something out of this? Because we're all heading in this direction, unfortunately, except me.
The last comment was that this was a great show. Definitely to have Ian back. And then people want to know where you got your hoodie from. I think
That's why I told you to sit up.
Oh,
Yeah.
I got this hoodie about a year and a half ago from the Nike store in King of Prussia Mall. Speaking of King of Prussia, we're only about 2 weeks away from opening our third office in King of Prussia. We're right on DeKalb Pike. The interesting thing, I knew it had to be mine, right? The address is 727 West DeKalb.
Look at that. Karma.
Karma. Our telephone number is 227-2727. Our address is 727 West DeKalb. It's a two-story brick building on the corner, directly across from Buckman Ski Rental, the new Netflix house. There's so much traffic goes by there. And we're looking forward to seeing our western suburb clients coming out to the King of Prussia office.
Opening party?
We might have a grand opening if enough people on live get their friends to watch live and build our audience. If we can get in, what's our audience now?
Right now we have 30 viewers on live.
30 viewers. That's disgusting.
We need 300 at least by next week.
300. I want 300 simultaneous viewers on live.
Give us 300.
And I will have a huge grand opening for our live audience only. Whoa. I'll announce it after the radio show, and only those on live will get to come to this, and I will have some fabulous food and prizes.
There you go. Fabulous.
Yes.
Food and prizes.
Yes.
So,
That went in?
A rim shot. Yes.
One of the questions was, are retirement facilities different than nursing homes as far as admission paperwork?
That's a good question.
So they're not different. They will have admission paperwork. Retirement communities are kind of the new forefront for private equity investment, which is one of the scary aspects of healthcare. Is people are seeing that it's a good way to get insurance money, Medicare, usually not Medicaid, but they set it up so that you're there, you come in independent, and they happen to also have for you if you need a little bit more help on the personal care assisted living facility, and then those assisted living facilities will also have memory care units, and then sometimes they'll have a small 15, 20-bed skilled nursing facility. They're not bad ideas, but again, the admission agreement is in there because even on the personal care home, which you can be independent, you just maybe have someone giving you your meds or something like that, you can still suffer neglect.
Is there a statute in Pennsylvania that specifically exempts you from having to sign the
I'm not 100% sure on a statute, but I just know case law is very clear that admission to a healthcare facility is not contingent on the signing.
So they cannot turn you down.
Right, but the personal care home side can't, and the nursing home side can't. But if you're in an independent living, which these campuses are big, they could have an arbitration agreement that would be enforceable because you're essentially just moving it into an.
It's an apartment.
Yeah, exactly.
But the thing you said was when you first get there, they show you the best and the wonderful facilities. And the first 30 days, or when that Medicare or when something else runs out.
Medicare, you get 90 to 100 days after qualifying hospital stay.
Right.
So typically, people end up in there because they're going for rehab. They had a hip surgery, or they went in and they were just there for 6-7 days and they decompensated.
Here's a valuable case. Somebody goes in to a nursing home because they were involved in an accident. I'm representing them. And they go from the hospital to the nursing home. They're in the nursing home for 30 days, but the treatment is so horrendous that they never leave the nursing home. And they may have been an income earner. Right. They weren't an old person who was eventually going in that direction.
Right. It was for rehabilitation.
For rehab.
Yeah.
Though if we work together in tandem on those types of cases, those cases become 7-figure cases.
Oh, they're big. And honestly, the type of cases that I'm getting in from the nursing home realm right out, I've been able to shift my bottom damages number to where we're probably taking everything that's over 500 at this point, and we're having to send them out anything under to other attorneys that we're referring to, because nursing home group is a small group countrywide. Not a lot of us do it, but I'm getting just old enough that a lot of my proteges are working at other firms and doing this type of work. But we're starting to see people going in a lot earlier, not only just situations like that, but there's medically complex with diabetes care, with obesity and things like that. And you're going in there and it's like, I just am not walking well. I need to go in there and get help. As soon as your insurance runs out and you go on to Medicaid, it doesn't matter whether you're 70, 80, 90, or 50, you're going to the same hallways. And when you're in those hallways, the staffing is going to be low, and it's going to be the issue. And you can be in as good a shape as you want. You catch an infection, you catch something that beats you down, you're eating crappy food. They spend like $6, $7 a day per resident. It's like prison food, and you're not eating.
Really be locked up.
Yeah, and if you're not getting your nutrition and you're not getting out, you're not moving around, it just creates this pattern where you don't get out. And the cynical side of me, which this was back in the days when I first started, and we're seeing it more now, nursing homes call these people at times clinical inventory. And you need heads and beds, and that's the census. And the way you keep your census high, you keep people dying on the back end, that bed opens up and you rotate in the higher payer, they move through, and it's just a conveyor belt for individuals.
It's like, what was that movie?
Coma?
Soylent Green.
Soylent Green is people.
Yeah.
Soylent Green is people.
And like I said, I do this all over the country, and Pennsylvania does have some of the better nursing homes in the country, because honestly,
when you go into a nursing home and they show you what they want to show you, what do you ask? Can I also see
the long-term care residents? Can I go see the memory care unit? Can I not see your short-term rehab? Short-term rehab is your Hilton. It's not anymore. Hiltons are terrible. That's I don't,
the Ritz-Carlton.
Ritz-Carlton, yeah. It is all the bells and whistles. Your staffing ratios are the highest. You see a nurse more often when you're in there, because, again, if they have good outcomes, they want people that do just go in for that little injury to get out, because then Lankenau or Penn go, well, because they can get penalized for rehospitalization too quickly. So they want to send it to a nursing home that is going to keep them for that 30 days. They're going to come out and they're walking away. It doesn't matter that rehospitalization rate when you're in the long-term care side. So they only care about making that beautiful side. So you should say, this is all well and good, but I want to walk the entire facility. And if I can, the residents are allowed to speak to you. Go into that long-term care facility, go into the day room, talk to the people sitting and looking at the TV. How often do you get taken care of? Are people responding to your call bells? How often does your family visit? Because that's a key too. You can't be there 24 hours a day. Do not go at the same time. Go as much as you can, but change your time up, because they'll have you clean. If you're coming there every day at 7:30, Dad's going to look great at 7:30. He doesn't look great.
Wow, another good tip from Ian Norris.
You hear that?
All right, folks, we're going to wrap up our live. Don't forget, if you find friends and family to join you on live, we're going to have a bash for our live listeners. We'll see you next week, same time, same place.